Well, hello and welcome to the Watchdog. My name is Liesl Wilson, of course, standing in for my colleague Vuyo Mvoko. On the show tonight, we will be speaking to Right to Know and the Centre for Applied Legal Studies after their victory at the Johannesburg High Court against the city. The city of Johannesburg has been charging fees for gatherings and protests. Political analyst Dr. Levi Ndau weighs in on the electoral amendment bill. The Concourt has given Parliament 6 more months to pass it into law. We'll also be marking International Albinism Day. The Watchdog starts now. Right, let's get into our top story tonight. The High Court in Johannesburg has delivered judgment in an application brought by the Centre for Applied Legal Studies, CALS, on behalf of the Right to Know campaign, the Gauteng Housing Crisis Committee, and community leader Keith Duarte. Now, this application challenged the City of Johannesburg's practice of charging protest conveners a fee to allow them to exercise their right to protest. The South African Human Rights Commission intervened as a friend of the court to emphasize how the policy does not comply with international law. Perhaps for more, joining us now to discuss is Stembiso Guluse and the program's organizer from Right to Know campaign, and Tandega Kati, who is an attorney at the Centre for Applied Legal Studies. Well, very good evening to the both of you. Thank you very much for joining us here on the Watchdog. Stembiso, let me perhaps begin with you. Obviously, looking at the irony of this all, the protesters that you often represent are people who are poor. They don't have access to resources. They cannot afford such fees. And we also understand that the ability to protest is a constitutional right. I wonder if you could just give us your reaction. How do you receive the judgment?
Well, good evening and thanks for having me. As the Right to Know campaign, this is a great victory for us. We are very happy with the judgment, and we also appreciate CALS for standing on our side. You know, this judgment is very important for people in South Africa, especially those who want to protest and want to hold the state accountable. You know, over the years, we have these challenges of this limitation of rights, especially when it comes to rights to protest. And as we have said, people on the ground, they are poor. They can't afford to pay these fees, which are unreasonable, and also they are unconstitutional. You know, so this is a great victory. People can now go and protest, exercise their right to call for accountability where necessary, without having these limitations when it comes to protest. Because, you know, this victory is not only for us as an organization, but for every individual who wants to exercise their rights of gatherings. And also, in a general view, when it's come to the right protest, it's been a challenge, you know, especially when it's come to these municipalities using these bylaws to make sure that they frustrate people where everyone wants to protest. Because it's not only in Johannesburg, but in other cities, they use different tactics when it comes to defining people their right to protest. So it is a great victory indeed. And at least this time, our will of justice are on our side, and we are very happy.
Let me bring Tandega back into the conversation. Tandega, if you can hear me, good evening. I believe that you're joining us via telephone tonight. We've just heard from Stembiso, you know, how they've received the judgment. And I wonder if you could outline the merits of the case and perhaps walk us through how you received the judgment today.
Thank you so much for having me, Liesl, and a very good evening to you. CALS welcomes the judgment. It's a great victory, as Stembiso has said, you know, for the right to protest in South Africa. I think as a matter of walking you through the case, the main issue here was the charging of fees by the city of Johannesburg as a precondition to the exercise of the right to protest, which the High Court had declared to be unconstitutional. We will know that the city of Johannesburg relied upon a policy, you know, to charge these fees. So they didn't rely on legislation, and they also didn't rely on the Constitution. So the Constitution in Section 17 clearly states that everyone, you know, has the right to protest, and so does the Regulation of Gatherings Act. And neither of them asked for a fee. So the court found that, you know, this policy is ultra vires the Regulations of Gatherings Act, as well as the Constitution. Because yes. So, and the court also reminded, you know, the city of Johannesburg and JMPD that ours is a participatory democracy, and the right to protest is pivotal in exercising our other constitutional rights. It was in the past and it still is today. And the JMPD had argued that the fees or the levies that they charge help with traffic control. But the court reminded them that traffic control is one of the core functions as the JMPD, so they cannot charge people or conveners for that. So all in all, we are very excited about this judgment and we welcome it.
Thandeka, what did those, the fees look like, perhaps for protesters? I mean, I believe there was a different rate for NGOs as well. I'm asking you this also because I wonder if we could also backtrack a little bit and look at where these claims, stem back to. If I am correct, it is from the 23rd of October 2020. Maybe you can clarify that for us, because the South African Human Rights Commission obviously came on board as a friend of the court.
So our understanding is that this policy came as a result of a resolution in 2011, so that's where it came from. That's where it originated from. Okay. The requirement to pay fees.
All right. I wonder then, just before I bring Stembiso back into the conversation, was this only limited to the city of Johannesburg, or, have there been other parts of the country that have been charging exorbitant fees, or fees for that matter, during protests? So walk us through that context as well.
Okay. So what was very interesting about this case is that through our research, we found that the city of Johannesburg, in our opinion, is one of the only cities in South Africa that charges fees before a person can exercise the right to protest. All right. So it was very unique to the Johannesburg setting.
All right. So it's going to be interesting to see how it then sets the precedents going forward. I wonder, as your arguments, were put forth, are you aware of any other protesters or prospective protesters who were denied the right to protest because they couldn't afford these fees, and the implications of that to date?
So I think even our clients, the issue was the affordability, because as you mentioned before, these fees were not fixed, so they would vary. Some people would be charged anything as little as 200 and something rands, while others were charged like up to 10,000 rands. So you can understand how this would be a deterrent for people to proceed to protest.
Yeah, absolutely. And I wonder with, the case of, with you obviously winning the case, how soon does the city of Johannesburg have to pay the legal costs for this case? What happens if they do not pay as requested? What do those scenarios look like?
Okay, so far, the judgment or the unconstitutionality of the policy was effective as of the 10th of June, so last week Friday. So going forward, the city of Johannesburg can no longer expect fees from our conveners. In terms of the right to know receiving costs for the case, that is an ongoing process that can take anything from a month to a year. So it's an ongoing back and forth between the attorneys about rates and so on and so forth.
All right, Stembi, so let me bring you back into the conversation. Obviously, you from a Right to Know campaign. I wonder, in your journey with the organization, are you aware of any prospective protesters or protesters for that matter who were denied the right to protest because they could not afford the fees? Perhaps what precedents do you think this sets going forward for the most vulnerable and marginalized in the country to exercise their constitutional rights?
Yeah, there have been some communities, especially grassroots communities and some community organizations who have tried before to protest, and they were denied because they couldn't afford to pay fees. I think that is one of the reasons, because as Right to Know, we also advocate for the right to protest. So smaller organization and community organization will also come to us for assistance. And we have realized that this is becoming an issue when they are trying to go to the streets and protest. So that is why we even taken up this case and reach out to CALS, because even ourselves, at some point, they wanted to deny us the right to protest and wanted to charge us. And then we said, no, we are going ahead. You understand our rights. It's on the Gatherings Act, so you can't do this to us. But you know what they usually do? They will limit the protection, they limit the services from the police. And that puts people who are protesting at risk, because they are no longer protected. At some point, even if they don't deny you these rights, they will let you go on the street, but they will deem your protest as being illegal, and you can end up facing criminal charges. So I think this victory, this judgment, will enable even this smaller organization who have been frustrated when it's come to, especially in the city of Johannesburg, as my colleague has mentioned, who have been frustrated when they want to take it to the streets.
All right. I want to thank you both for your time here tonight, perhaps just giving us perspective upon that judgment. The High Court in Johannesburg having delivered judgment in an application brought by the Centre for Applied Legal Studies on behalf of the Right to Know campaign, the Gauteng Housing Crisis Committee, and of course, community leader Keith Duarte. Again, thank you very much to Stembiso Koluse, the program's organizer from Right to Know campaign, and Tandega Kati, attorney at the Centre for Applied Legal Studies. Let's quickly take a quick ad break and continue with more news and updates on the other side. You're watching The Watchdog. Welcome back. The Watchdog continues with myself, Hazel Wilson, of course, standing in for my colleague, Vuyo Mvoko. In other news, MPs working on processing the Electoral Amendment Bill will meet right through Parliament's recess period to finalise this legislation. Parliament has been granted a 6-month extension by the Constitutional Court to pass this bill into law. However, critics of the bill in its current form say it still does not go far enough to give voters the chance to elect their chosen representatives.
In 2020, the Court ruled the Electoral Act to be unconstitutional in that it didn't allow independent candidates to contest national and provincial elections. It gave Parliament a deadline of 24 months to amend the law. That deadline was last Friday, the same day that the Court granted Parliament its request of a 6-month extension.
We've further made an application to continue with the work during recess so that we deal with this process extensively. Secondly is that it will allow the NCOP to also further deliberate and look on this electoral amendment bill once the National Assembly has considered and recommended and referred the further processing to the NCOP.
An impression is being created that the fact that we are not ready with this bill is threatening the national elections in 2024. And I don't see in what way it is threatening the elections. According to the reports which I have received from the legal team, I know that we are really gunning for the 6th of November to finalize this whole thing. And therefore, if we finish and the president signs, then we will not have a problem if we are able to do it in the next 6 months.
But one South Africa Movement's Musi Maimane says this bill still favours political parties over independent representatives.
And so a 6-month extension, whilst granted by the Constitutional Court, will mean that Parliament will sign into law a bill that still does not achieve, A, for people to vote for their members of Parliament directly, get to know who represent them on issues of health, education, crime, and furthermore, ensure that accountability for issues such as state capture is felt across the entire political practice.
Other critics agree with Maimane, saying the bill currently does not give independent candidates an adequate opportunity as they are restricted to contest for only 200 of the 400 seats in the National Assembly. Supporters of the bill want all 400 members to be elected through a constituency-based system. Parliament anticipates the bill will be sent to the President in September for assent, giving him enough time to study it and send it back to the institution if he has any concerns.
Abra Barbia, SABC News, Parliament.
Well, joining us now to discuss further, we're joined by Dr. Levi Ndau. Well, very good evening to you, Dr. Levi. Thank you for joining us here on the Watchdog tonight.
Good evening to you, Liesl. Good evening to the viewers at home. Thank you for having me.
We've just seen the context being set by Abra Barbia, our reporter, and I wonder if you could highlight, how this electoral amendment bill, in fact, highlights the impact of politics on lawmaking. What's unfolding on that front?
Well, I think it's important to note that the Electoral Act, before it was declared unconstitutional, it only recognized politicians who would actually participate in the elections only through political parties. And that would actually happen at provincial and national level. And as it was, it would prevent individuals to participate as independents or as individual citizens. It also only recognized citizens having to participate as individuals only through a vote and not recognize them to stand as individual candidates. But recently, the Court has taken a decision that individuals are therefore allowed to stand for elections and, of course, to stand as representatives in the National Assembly. The integrities that we have now is that it appears as if some political parties still want to see the status quo remaining. Hence, there is now a proposal to only have, even though they have no choice, that the Court has taken a decision, they only want to cut that and only have 200 seats allocated for independents or individuals to participate in the elections. And those that are for independents are still arguing that it still gives an advantage to individuals who contest elections through political parties and not give full advantage to individuals. And I start seeing a situation where this matter might still have to be referred back to the Constitutional Court, because I see those who are for the independence still going to argue that it remains not giving sufficient rights to independent candidates. And of course, what they wanted from the onset is to ensure that all individuals who wish to be elected or to stand as candidates in the elections be given an opportunity to stand, irrespective of the number of seats that can be allocated in the National Assembly.
Well, time becomes another factor that, obviously has been brought into this equation with the extension for further 6 months. As we head into national elections in 2024, the need for this legislation to be enacted becomes rather imperative, Dr. Levi. And I wonder, is there sufficient time to prepare for the 2024 elections? Obviously, the IEC, has previously stated that on average it requires about 2 years in preparation. What's your thoughts on that?
I would agree with you that time becomes a factor, because the IEC, when they had a meeting with the Home Affairs Committee, they spoke about logistical issues, they spoke about redemarcation, they spoke about retraining, and they also spoke about the budget. And that for me, and equally, they spoke about preparation, which has to take almost 24 months for elections to run properly. And if indeed we have this kind of an extension for 6 months, it might have an impact on the work of the IEC. And equally, you also want to see the Parliament respecting the decisions of the court. And that for me would put a huge strain on the IEC, because it appears to me that there's going to be a lot of work that the IEC would be expected to do. Maybe the Parliament might be able to push their work and ensure that they finish as fast as possible, so that the IEC will then be given sufficient time to be able to prepare for the elections.
Well, Dr. Levi, given the vagueness of the electoral model as well, amongst other issues, based on the Concourt's ruling to these amendments, what concerns are also rising on that front?
Well, the concerns for me would still stand. The concerns will be related to the training of personnel. The other concern would be on the matters relating to the demarcation. And of course, there are matters that will be related to electoral education or voter education in terms of reintroducing the new model to the ordinary citizens on the ground. We have got the illiterate, we've got the elders, and of course we have different constituencies that will still require to be given sufficient information and voter education on how they're supposed to participate in these elections. Equally so, you'll also expect finance to be able to release financial resources that should be directed at supporting the project of the IEC. Because if now we have to allow independents to participate, it will require more financial resources, the logistics relating to ballot papers and the constituencies must also be addressed. So those are the challenges. But the advantage that we have is that these are the challenges that are known to the IEC as we speak today. And of course, I would expect the IEC to have started the work so that they're able to deliver credible and acceptable results.
Well, speaking of the IEC as a Chapter 9 institution, Levi, I mean, obviously, just before we get there, we've seen that many of the proposals that have been put forth to date has been based on the 2003 Frederick van Zyl-Slabbert Commission report that, recommended a mixed system of directly elected constituency MPs and PR candidates. And obviously, this electoral bill is going to impact, on quite a number of fronts. And there remain some flaws to date in the bill, just in line with the Constitution and upholding the rights enshrined there. So for me, again, another issue that comes to the fore is the issue of leadership with the Chapter 9 institution. I mean, we obviously seeing that IEC commissioner position is vacant. And I wonder how this is now also going to impact, given that we haven't really heard much from Parliament since May, around the 10th. Walk us through what this impact of the vacant IEC commission is also having on scenarios unfolding.
We are lucky in South Africa that the lawmakers are given an opportunity to make laws for us, and sufficient time is being provided for them to do so. Equally so, when they execute their responsibilities, they also have to consult as widely as possible, bring experts, bring people who have got experiences on matters of elections, so that they are able to provide insight so that this matter is actually dealt with in an appropriate manner. My expectation will be that the Parliament will also have to be in consultation with the IEC so that they are able to know and understand the different areas of concern that the IEC might also be able to raise. What I will not expect is a situation where Parliament will then come with another extension, or Parliament also having to come with positions that might contradict our own laws. That is something that I don't expect from Parliament. My expectation is that Parliament should actually do as put down by Concord, but equally, the IEC must match the task and deliver on its mandate to provide elections which are credible, which are free, which are fair, and obviously which will be acceptable to all the citizens. It is the situation that we're facing, and unfortunately, there is no turning back.
Well, 28 years into democracy, Dr. Levi, I wonder if you could then elaborate on whether this electoral reform, ultimately is going to ensure accountability, linking, representatives in legislature to constituencies on the ground, perhaps further democratizing our electoral law at large. What are your thoughts?
Well, there are a lot of people who still appear to be worried about the systems that we have now. Different political parties would use party lists. And in these party lists, candidates are not attached to any particular constituency. Yes, of course, parliamentarians are being assigned different constituencies so that they are able to go and deal with matters of those constituencies. But the unfortunate part is that most MPs, if not all, are not able to service their constituencies, and they end up not knowing exactly what is happening in the constituencies that they are assigned to. But in the proposed amendment, citizens would be given an opportunity to vote for people who reside in their areas, people that they know, people that they'll be able to interact with on a regular basis, because these are the people that will be found in their own areas. And that is the argument that people who wanted independence to contest are actually raising. Whether it is the best model, whether it is going to work, that is something that we still have to wait and see. But it appears as if it is challenging the status quo, which had challenges that are actually known, and they've clearly been outlined by those who push for the amendment of the Act.
Well, speaking of power and perhaps giving power back to the electorate at large, I wonder, in your opinion, between election periods and beyond elections, beyond 2024, how do we begin to give more power to the electorate at large?
When people wanted democracy and when South Africans fought for freedom, what they expected was that they should continuously be part and parcel of decision-making in government. They expected their views to be heard on policy issues, on service delivery issues, and a variety of issues. When we move towards this system, I think the expectation is that citizens on the ground, even though it is happening now, that citizens are being consulted on a variety of issues. I think the expectation now is that citizens will then be able to have a direct contact with their elected representatives at all levels of government, either national, provincial, and local government. And they will then be able to raise their concerns, knowing that they will actually reach the very same people who actually represent them. I know there might be challenges in terms of delivering the message in a manner that is expected by ordinary citizens. But I think when citizens raise issues directly with elected representatives, when they see the challenges on the ground on a regular basis as elected representatives, society or communities will feel that indeed we are properly represented, even though it might have its own challenges.
Dr. Levi Ndau, thank you very much for your time here tonight. Again, the Constitutional Court has granted Parliament an extension of the deadline set in its New Nation Movement MPC ruling in 2020 to amend the Electoral Act to allow independent candidates to be elected to the national provincial legislatures this until December. Again, thank you very much to Dr. Levi Ndau for giving us the analysis on what the impact of this electoral reform ultimately means for the electorate and exercising its power at large. We're going to take a quick ad break and continue with more updates on the other side. You are watching The Watchdog. Right, welcome back. You're watching The Watchdog with myself, Liesl Wilson. Let's take a look at some of the other stories we are highlighting tonight. Back in 2013, the United Nations Human Rights Council adopted a resolution calling for the prevention of attacks and discrimination against persons with albinism. The date set for the International Albinism Awareness Day annually is the 13th of June. The theme for this year is United in Making Our Voices Heard. Joining us now is Nomasonto Mazibuko, founder and director of Albinism South Africa. A very good evening to you, Nomasonto. Thank you for joining us here on the SABC.
Good evening. Thank you for inviting me, and thank you to the viewers.
Nomasonto, people with albinism face numerous issues. I mean, they suffer from misconceptions, behaviors, social isolation, labeling, incorrect beliefs. I wonder if you could quantify the cost of this form of discrimination to people with albinism.
You know what a difficult question to quantify it. You're born with this discrimination from the labor ward when your mom is supposed to bond with you. The midwife asks your mom to say, who in your family looks like this child? So from there, you are now fed with this discriminatory breastfeeding where your mom is just devastated to say, what have I done to be given this child? And very rare are there any people with albinism that we can know of, because albinism happens within 2 to 3 generations. So there's no history of anybody having this the condition in your family.
Well, this obviously also speaks to the education, understanding the narratives and perceptions that people with albinism face. And I wonder if you could speak to that, perhaps since the United Nations declared this back in 2013. What does that landscape look like? How much further do we still need to go in conscientizing ourselves towards the discrimination faced?
Firstly, we need our government to be very, very conscious in activating the incidence of albinism. We are now at the stage where the United Nations have declared albinism a disability. Secondly, we are in a stage where we're having action plans of different countries, and yet the United Nations have given countries to sign, but South Africa has not started to equip themselves as government to accept. We have an action plan where the independent experts came to South Africa and sensitized government and different departments to say people with albinism are people first before their genetic disorder.
Well, what's your call to action then for government?
Yes, we've got an action plan that we've presented to the Department of Women, Youth and Persons with Disabilities. And we were promised that this action plan will be tabled in Parliament. But we have since waiting. And today it's International Albinism Day.
Yes.
But none of the governments have come in to say, let's celebrate, let's educate, let's amplify the fact that people with albinism are people first.
Well,
before they are. I want to amplify the fact that I'm Nomasonto as a woman before being a woman with albinism.
Yes, absolutely. I wonder then how government's action or lack thereof speaks to the theme for this year, as appointed by the United Nations, because it is about, standing united and making our voices heard.
We have ignored government deliberately, but we as people with albinism in South Africa have united. We are going to have a conference speaking to ourselves so that we educate government to say we are part of the people. The Constitution of South Africa says Nomasonto is as important as Lizelle, but when we look at situations, there's a lot of inequality in this country.
Let's speak about that inequality, Nomasonto. I mean, what are some of those more pressing issues coming from people with albinism? What more needs to be done at this point? I mean, 2013 was a few years ago.
Firstly, acceptance from the family into the community, to the school, into the workplace. It's worse where you find you are qualified. You've got everything that is required from a perspective of you at your workplace, but you are still discriminated at your workplace. People still call you names. And even if young people today are going for interviews, you can see from the panel that they don't take you seriously and they are not even convinced that these qualifications belong to you because you're a person with albinism. But nevertheless, as we're saying this year, united in our voices, we will make it. That is why we're saying, as persons with albinism, we will be very, very conscious and we will not lose heart and we will not lose the momentum of engaging with government, of engaging with our peers, with engaging with whoever still look down. The discrimination of persons with albinism, there's much to be desired in this country.
No, absolutely. I mean, it speaks to the politics of recognition and how important representation is. And, I want to extend this conversation perhaps by not only looking at South Africa, who's obviously part of a continent, but what the challenges are perhaps for people with albinism further afield on our continent versus its Western counterparts. What's also being observed on that front, and how are we also mitigating against some of those challenges?
Africa believes in color. If you're still not the color that they require, which I don't want to get into to say we are black and proud, but we still find that even the AU still discriminates where we need to have a person with a special envoy to represent people with albinism. And the worst part of it is that Africa still is patriotic and it still have patriarchy. Men still look down to say, what can this woman tell me? Mark you, this woman has albinism. Because remember, it started in Africa that our body parts are sold to other people for they to gain from our body parts. And it surprises me that all the people in Africa say, when it suits them, we are a curse. When it suits them, we are a blessing. They are so beautiful. They are a blessing. But how can you take a curse and mix it with a blessing? And yet you want to take my magic hands to touch your business, to flourish, to touch your company to flourish, to touch your congregation to grow in numbers. Today we are sitting here as persons with albinism to say, really, are we a blessing or a curse? Let's take a straight line to say, we can't be on the fence. When it suits you, we are a curse. When it doesn't suit you, we are a blessing. So we are united in our voices to say, enough is enough. We are going to be united and prove to the world that people with albinism are people first before their condition.
Nomasonto, perhaps as I wrap up this conversation, on the back of what you'd echoed, we obviously can't ignore the systemic issues that, some of this discrimination stems from. But perhaps as today is the day that we commemorate, I wonder if you could walk us through what some of the initiatives were for today. Do you think it was sufficient? And going forward, what seems to be the plan of action in terms of tackling some of the more the low-lying fruits in terms of the challenges faced leading up into the long term?
It's not going to be enough.
Yeah.
But all what we're doing as a sector, as the Albinism Society of South Africa, is to engage with parents to say, love your children so that they get confidence from home. Secondly, people with albinism should go to school. We are going to have an ammunition by becoming educated so that we fill the posts and the vacancies that are there by being united. And we are going to unite as persons with albinism and speak with one voice to say, as we venture into the 21st century, people with albinism are going to take their places in the communities, in the places of employment, in the leadership positions that are there. So all we say, with the action plan that we have presented to government, we're waiting earnestly to be called. Our time will come. And meanwhile, we are uniting. We are a very forceful group or sector to be reckoned with.
Nomasonto, I wonder just quickly before we go, obviously you being the director of Albinism South Africa, your work that you've done to date, its impact that it has had on people with albinism. Can you walk us through what some of those success stories have looked like in terms of empowering people, in terms of, highlighting that they've seen, they're heard, and that they matter? I wonder if you could share some of those, perhaps for a lot of people who are far removed from your lived reality.
First and foremost, I would boast with the confidence that I see in the arts. Look at the people with albinism. Look at South Africans dyeing their hair just to be like our hair. And then, secondly, people with albinism are educated now. They are working hard to be heard and not only to be seen. They are walking the talk to say albinism is a manageable condition. Thirdly, parents of children with albinism no longer hide their children. They are proud that the children with albinism should go to school. And let me say to you, albinism is not a one-size-fits-all. Our equity is not the same. Those children who belong to have a low vision must go to the school of the blind. Those who have a little bit of vision are working very hard. And I can safely say to you, we have a lot of people that we boast about, which I would not tell you about. You know yourself, you've seen us, specifically on the arts. And as we walk tall as persons with albinism, the Albinism Society is very proud that people with albinism are now featured in most of the sectors in South Africa.
Nomasonto, it's always about ensuring that dignity, justice, equity and equality reigns. Thank you very much for your time here on the SABC again. Nomasonto Mazibuko, Director of Albinism South Africa, chatting about, International Albinism Awareness Day. This is as declared by the United Nations, the UN Human Rights Council, who adopted a resolution back in 2013. Again, just looking at how we prevent the attacks and discrimination against persons with albinism. Again, thank you very much, Tuha, for joining us here on the SABC. Perhaps before we leave you, suspended Public Protector Advocate Busisiwe Mqwebane plans to challenge President Ramaphosa over her suspension. Mqwebane maintains that the president is conflicted in the matter. Last week, he suspended Mqwebane on the eve of the ruling by the Western Cape High Court. Mqwebane says she was shocked by the decision. She, of course, was on the Full View early on.
The letter which was written to the president after we were requested to respond by the 26th of May, they also indicated that we need them to commit and engage us on time and respond to us what the way forward would be before even him deciding to suspend. So that's why we were caught by surprise with my legal team.
So if I'm listening to you correctly, Advocate Mkhwebane, you're saying that you were not told before the public was told that you're suspended?
Yes, Bongiwe, I was at home, well, from the office. I also received a message from one of the journalists requesting me to share the suspension letter. And when I opened the news and Twitter, I saw the news that I am suspended. Indeed, it was a shock and worse because I expected them to respond to my legal team because we wrote the letter through my legal team. But then the letter I discovered later, after 5 or 6, that it was sent to my PA, who then had to forward it to me, but already the information was out there.
Well, we have come to the end of the Watchdog. Thank you very much for tuning in. Of course, my colleague William Voko is back tomorrow. Do stay safe and take care. From myself, Liesl Wilson. Until next time, it's goodbye for now.